Good morning, friends. Today we will take an area where medical science and legal science both do not go together. They share some similarities and some differences. This is insanity or unsoundness of mind. Before proceeding further, I would request all of you to like, share, and subscribe the video and channel. Insanity or unsoundness of mind was a defense when mens rea became an essential component of criminal liability. During primitive stage, mens rea was not an essential component of criminal liability, and at that time a person was punished on the basis of external conduct only. In those days, the position of insane offender was worse than the normal offender. He was held guilty of the actual offense committed by him, and he was also seen as a result of retribution for the act against divinity. Because of that, he suffered from insanity. So he was in fact doubly punished. Recognition of mens rea as a condition of criminal liability is a later development. And with that, unsoundness of mind or insanity due to advancement of knowledge became one of the exemptions of criminal liability. Unsoundness of mind is not a very good defense in the sense that it has been a controversial defense. The questions are that how the unsoundness of mind will be judged. Secondly, what should be the test to determine unsoundness of mind? Whether the defense is available to person, a normal person, as an alternative to innocence, or he could plead only innocence and or unsoundness of mind, as the case may be. In beginning, wild beast test was developed, or wild beast test was applied, and this test was laid down in R versus Arnold. Here, the accused was tried for wounding and attempting on the life of Lord Onslow. Justice Tracy laid down the test of wild beast and held that the accused was not guilty of the offense. According to this test, and as Tracy Justice said, that if the accused was under the visitation of God and did not know or could not make distinction between good and evil, and also behaved like an infant or beast, he was eligible for the defense of unsoundness of mind or insanity. The test is strict and vague also because it depends upon that the person must act at the relevant time like a beast. However, the test is also known as good and evil test and was further approved in Lord Ferrer's case. In Lord Ferrer's case, Earl Ferrer had actually shot his steward dead in revenge for some imaginary wrong. The court held that test of good and evil was good. It was approved here. As said that the criticism against the test is it is arbitrary and secondly strict. Arbitrary because good and evil vary from person to person, place to place, time to time, and strict because the behavior of person is equated with the behavior of animal, beast. Later on, this test was dropped in preference to insane delusion test. Insane delusion test was laid down in 1800 in Hadfield case. In Hadfield case, the accused was suffering from delusion that he was destined for God to save the mankind as the world was coming to an end. In those days, suicide was regarded a wicked act, and therefore he decided to eliminate the King George III in order to be hanged for the offense. If the wild beast test would have been applied, he would not have escaped punishment. The court here applied insane delusion test. It was laid down in this case and he was acquitted of the charge. Under insane delusion test, and the court sees whether accused had the knowledge what he was doing. Counsel for the accused argued that the accused suffered from delusion. It totally deprived of his understanding and faculties were overpowered by this delusion. This, therefore, insane delusion, a fixed insane delusion, was the direct cause of crime in this case. The court upheld the plea of insanity. Again, this is a vague test. Now it was difficult to judge whether the person was suffering from delusion or not, and therefore very soon a new test came into being. This was capacity to make a distinction between right and wrong. The court said that if the accused was capable of making distinction between right and wrong, he was not eligible for the defense of insanity. Right and wrong, again, vague, involve arbitrariness, vary from person to person, time to time, place to place. Hence, soon it was discarded, and in 1843, Magnaton test was developed and evolved. In Magnaton case, the facts are very simple that Magnaton was afflicted by the delusions and wanted to kill Sir Robert Peel, then Prime Minister of England. He shot at but missed the target and killed his secretary. Now the question arose whether he was guilty of the offense or not. On his behalf, the plea of unsoundness of mind or insanity was taken. In this case, 5 questions were answered by the judges, and the answer of 2 and 3 is known as Magnaton rules. Now, I just read out what was laid down and what was said by the House of Lords, that the jurors are to be told in all cases that every man is to be presumed to be sane and to possess a sufficient degree of reason to be responsible for his crimes, until the contrary be proved to their satisfaction, and that to establish a defense on the ground of insanity, it must be clearly proved that at the time of committing the act, the accused was laboring under such a defect of reason from the disease of mind as not to know the nature and quality of the act he was doing, or if he did know it, he did not know he was doing what was wrong. In simple language, Magnaton rules are three. First, the accused must be presumed to be sane until the contrary is proved. Secondly, the accused must be suffering from the defect of reason, that is insanity, from disease of mind at the time of doing the act. Thirdly, the accused must suffer from the defect of reason, from the disease of mind, and he did not know the nature and quality of the act, or if he knew it, he did not know that the act was wrong. Magnaton tests at that time were regarded to be the good test, laying down good norms. Later on, these rules also suffered from some defects. Now we come to the criticism of the rule. Magnaton rules again say that the man did not know that the act was wrong. Clearly, the test is based on right and wrong. Right and wrong test is only concerned with the rational knowledge of man. It ignores completely vital questions like emotions, unconsciousness, will. A person may be of unsoundness, may be of unsound mind because of emotions, will, and consciousness. This aspect is ignored in the test. Secondly, the meanings of the word right and wrong are not clear. Whether these words have been used in legal sense or in moral sense. In one case, R versus Windle, the court held that these terms have been used in legal sense, but in an Australian case, it was held that the test was used, or the terms were used in contrary sense. Then the rules recognize only two cases of insanity. It recognizes the extreme case of insanity. The person would be either sane or insane. So only two things can happen, that the person is either sane or insane. But we know that there are different shades of insanity that have not been recognized under the Magnaton rules. Moreover, the words right and wrong are relative terms. The meanings are flexible, vary from time to time, place to place, and man to man, and therefore discretion has to be exercised. The moment it comes, some arbitrariness comes in the test. Moreover, the defense of insanity has to be raised by or on behalf of the accused specifically with the consent. The defense is not available if the person pleads innocence. So innocence or unsoundness of mind, insanity, both cannot be claimed together, even if there is clear case from the facts and circumstances that the accused was suffering from insanity. Rest part next time. Thank you.